All right, the court is calling 2021 CR 4788, State of Texas versus James Lawrence Steagmire. Can I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense?
John Coons for Mr. Steagmire.
And are you Mr. Steagmire?
Ma'am.
Are you Mr. Steagmire?
Ma'am.
All right, you entered a plea to count 3, which is indecency by contact. You entered a plea of no contest on September 13th. There was a request for a PSI report, TAP evaluation, and MIG-MILF evaluation. And of course, through the nature of the offense, he's not going to be eligible for MILF. But have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Yes, Your
Defense?
Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
According to the plea bargain agreement, it's a cap of 6. The state is remaining silent on your application. All right, defense, is there anything you wish to say on behalf of your client?
Judge, if you'll recall, this is an individual who I struggled with, not with him personally, but because he had been diagnosed with dementia about 20 years ago by the VA. This is something that I had him evaluated for. Dr. Scott did at least one evaluation. I provided numerous documents to Dr. Scott and to the jail where my client's been sitting for the last, year and a half or so. Unfortunately, Dr. Scott, fortunately and unfortunately, Dr. Scott found him to be competent and did not see the same issues relating to my client's Parkinson's that the VA did. With regard to all of that, obviously I trust Dr. Scott, having known him, he's been around for a long time, and I understand his evaluation. I had him actually reevaluate my client based upon some additional information that I provided. He sent back a further evaluation stating that it didn't basically change his opinion of things. At that point, Judge, my client and I decided that the entry of a plea would be in his best interest. Judge, it's never easy for you to have a case like this in front of you with victims and especially someone that was a child at the time. I would tell you, Judge, though, that—
Excuse me, I'm sorry, just a moment.
Mhm.
All right, yes.
Okay. Let's see, where was I? With regard to cases like this is obviously difficult for a court to even contemplate probation sometimes. However, we are asking that you give him that chance. My client is not a child anymore. He's an elderly man at this point in his life. And given all the health problems that he's had and with the Parkinson's, with the other issues that he has, I don't think he'll be any sort of danger or risk to the community while he's on probation.
So counsel, does he have dementia or does he not have dementia?
Well, so he has Parkinson's, and the VA has diagnosed him with Parkinson's related dementia. This goes back approximately 20 years. Again, as I was telling the court earlier, I provided all of that documentation to Dr. Scott. Dr. Scott met with my client and had determined on 2 separate occasions that my client is not incompetent. So, I'm not sure what I'm supposed to do beyond that. And the reality, judges, I have not seen maybe the signs of dementia that would cause me to request a second doctor to evaluate him. Dr. Scott did the 2, and
Excuse me, Deputy Laura, you've dimmed the lights on us. You've dimmed the lights.
so,
Yes.
Judge, I would ask that you do give him the opportunity to be placed on deferred adjudication. He will have to register.
I'm sorry, Deputy Laura, you dimmed the lights. I mean, there's a lot of things wrong with it, but I mean, we are close to October 31st. Okay. All right, yes.
So, Judge, again, with regard to my client's sentence, we're asking that you give him the opportunity on deferred. He will have to register as a sex offender. We understand that. He understands all of the conditions that he will have to comply with. The probation will not necessarily be easy for him. This is, again, with his health issues. I do believe that a placement in the MIC unit, if that's possible, would be very beneficial to them. The one last thing I'd like to point out, Judge, is that the complainant did not communicate with the probation department. I know that that's not necessarily something that can be examined one way or the other, but this is not a complainant who is raising cane with the court or raising cane with the DA's office about what should happen to them. So I would ask that you, given all of the information that I've provided to the court, that you consider that my client's application for deferred adjudication and place him on the deferred.
All right, Mr.
Judge,
Steck.
I know we're silent, but just as a factual issue, the victim is here after sentencing to provide a victim impact statement.
Okay. All right. And so, Mr. Steagmire, I want you to know that I've listened to what your attorney has said. I've internalized it, and I have read and combed through the PSI report to review everything. So what I can tell you in this court, and I think your counsel knows this, for me, I look at each case individually. It does not concern me, or I don't take into my consideration of sentencing whether there's media, not media, because to me, each case is supposed to be looked at individually and sort of in a vacuum of that case. The same way I tell jurors not to pay attention to anything that's on the news, I do that as well. All right. Is there anything you wish to say?
No.
All right. The court is going to deny your application. The court will find you guilty. The court will sentence you to 5 years in the prison, give you credit for any time served. There's to be no contact with any minor children, no contact with any of the complainants in this case or the complainant's family, and Chapter 62 compliance. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review this document with your attorney? Did you understand it? And did you sign it?
Ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. You said there's, all right, and then Mr. Cisneros, I'm going to take your case up next.
Thank you.